Recognition.
Mr. Speaker, by direction of the Committee on Rules, I call up House Resolution 462 and ask for its immediate consideration.
The clerk will report the resolution.
House Calendar number 64, House Resolution 462, resolved that upon adoption of this resolution, it shall be in order to consider in the House the bill, H.R. 3192, to provide for a temporary safe harbor from the enforcement of integrated disclosure requirements for mortgage loan transactions under the Real Estate Settlement Procedures Act of 1974 and the Truth in Lending Act, and for other purposes. All points of order against consideration of the bill are waived. The bill shall be considered as read. All points of order against provisions in the bill are waived. The previous question shall be considered as ordered on the bill and on any amendment thereto to final passage without intervening motion except one. 1 hour of debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services, and 2, 1 motion to recommit. Section 2. On any legislative day during the period from October 12, 2015 through October 19, 2015. A. The journal of the proceedings of the previous day shall be considered as approved, and B. The chair may at any time declare the House adjourned to meet at a date and time within the limits of Clause 4, Section 5 of Article 1 of the Constitution, to be announced by the chair in declaring the adjournment. Section 3. The Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 2 of this resolution, as though under Clause 8A of Rule 1.
The gentleman from Ohio is now recognized for 1 hour.
Mr. Speaker, during consideration of this resolution, all time yielded is for the purpose of debate only, and I now yield the customary 30 minutes to the gentleman from Massachusetts, Mr. McGovern, pending which I yield myself such time as I may consume.
Gentleman's recognized.
Mr. Speaker, I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks.
Without objection, so ordered.
Thank you, Mr. Speaker. Mr. Speaker, on Tuesday, the Rules Committee met and reported a rule for House Resolution 3192, the Homebuyers Assistance Act. House Resolution 462 provides a closed rule for consideration of H.R. 3192. The resolution provides 1 hour debate equally divided between the chair and ranking minority member of the Committee on Financial Services. The resolution also provides a motion to recommit for the bill. In addition, the rule provides the normal recess authorities to allow the chair to manage pro forma sessions during the next week's district work period. Mr. Speaker, I rise today in support of the resolution and the underlying legislation. For more than 30 years, federal law has required lenders to provide two different disclosure forms to consumers applying for a mortgage. The law also has generally required 2 different forms at or shortly before the closing of a loan. 2 different federal agencies developed the forms separately and under 2 different statutes, the Truth in Lending Act, TILA, and the Real Estate Settlement Procedures Act, RESPA. The Truth in Lending Act provides meaningful disclosures of credit terms to enable consumers to compare their credit terms available in the marketplace more readily and avoid uninformed use of credit. The Real Estate Settlement Procedures Act of 1974 exists to ensure that consumers are provided with greater and more timely information on the nature of costs of their residential real estate settlement process and protected from unnecessary high settlement charges caused by certain abusive practices that Congress found and made sure that we got rid of. On November 20th, 2013, the Consumer Financial Protection Bureau finalized the TILA-RESPA Integrated Disclosure Rule, or TRID, which combined these 2 forms that had been separated for 30 years so that consumers can receive uniform information on one form on both their TILA and their RESPA information. The new disclosures are generally referred to as the combined or integrated disclosures. The Integrated Disclosure Rule requires loan originators who receive an application to provide consumers a loan estimate that combines the initial TILA disclosures and the good faith estimate. While intended to streamline the current duplicative disclosure regime under TILA and RESPA, the integrated disclosure rule poses significant implementation and compliance challenges. It makes significant changes to the origination, processing, and closing of mortgage loans, requires business decisions at all stages of the transaction, and includes difficult to understand timing and delivery requirements and other practical implementation issues that go beyond the form and content requirements. Mr. Speaker, the rule we're discussing today is very substantial. In fact, in front of me, it has 1,888 pages of new requirements. This is a massive regulatory change, and there needs to be time to adjust to its implementation. I think we all agree on that. I heard yesterday in the Rules Committee the ranking member from the Financial Services Committee agree that there does need to be time to adjust to the implementation. In fact, just this last week, I was in Chillicothe, Ohio, visiting the offices of a real estate company that had a title agency next door and a closing agency, and they were very concerned about the potential harm to home buyers that might see their closings delayed or, in fact, the whole process just seized up if we don't figure out how to implement this regulation in a thoughtful way and allow a time for transition. As I said, everyone agrees that less paperwork and more streamlined processes are positive steps for Congress and the regulators to encourage. However, given the complexity of the integrated disclosure rule, I believe Congress must also give those affected by this rule time to implement the changes in a thoughtful way. In fact, Mr. Speaker, I, along with the gentleman from Massachusetts and 250 of our colleagues in the House, signed a letter in May asking the director of the CFPB, Richard Cordray, to implement a hold harmless period for parties affected by the rule as they attempt to comply with the new regulations. I ask unanimous consent to submit a copy of that letter for the record.
Without objection, so ordered.
Yet here we are today, just a couple of months later, and some of my friends on the other side of the aisle are going to argue that we shouldn't institute that very same hold harmless period by passing this bill. As I said, I think they agree with it. There may be other things in the bill we can talk about that they have a problem with, but we all need to pass this bill because we have to have a hold harmless period to make sure that people that want to close and buy a house and people that want to provide them that service can do so as we implement this new regulation. Almost half the Democrats on the Financial Services panel agree that this hold harmless provision should be in place because the vote on the Financial Services Committee was 45 to only 13. Mr. Speaker, just last week, the Financial Services Committee held a hearing, the semi-annual report of the Consumer Financial Protection Bureau, at which Director Cordray testified and fielded several questions about these new rules. When asked by the gentleman from Kentucky, Mr. Barr, whether he thought the grace period, whether he could implement a grace period that would allow folks to find their way through this, and realtors and title agents so they could count on not being the focus of enforcement but could learn how to do this, Director Cordray responded, "Look, I don't think it's appropriate for me to say I won't enforce the law when that's my job to enforce the law, but I think what I've said to them is we're going to be diagnostic and corrective, not punitive, in that early period." I think they're going, if they...
Do you hear that? They're not going to enforce the law.
Read between the lines, they'll understand that we're trying to allow them the latitude that they've asked for. I think people should take yes for an answer. The problem is that's not yes for an answer. It's unclear. And that's why this bill is so important, because it is clear. And this will make sure that we provide an implementation period that allows a hold harmless period for industry participants. Just 2 days later, in fact, the director, in a letter to some industry groups that ask for this same request of a hold harmless period, refused to say he would institute a hold harmless period. So even though what he said to the committee sounded like he's going to try to do it, he said to them that he would not be able to institute a hold harmless period. So I think there are clearly some inconsistencies there that mean that we need to pass this bill. This bill will ensure we hold harmless almost everybody that does this, instead of doing it with a wink and a nod. The House, 60% of the House, I believe, is supportive, and we'll see what, obviously we have a vote to take on this, but we signed a letter that asked for this, so I believe that you'll see a pretty good bipartisan vote today. This massive regulatory undertaking needs to be implemented in a thoughtful way. That's all this two-page bill does, is create a safe harbor for enforcement until February 1st of 2016. It also includes a good faith exception to ensure that if somebody acts in good faith, they also will not be subject to legal action, just like they won't be subject to enforcement action. And let me be clear, that only applies to somebody that acts in good faith. The courts have dealt with good faith exceptions on many other issues, and it is clear that the courts understand what good faith is, and that'll be litigated case by case whether somebody was acting in good faith. And if they were acting in good faith, there won't be any legal action. If they weren't acting in good faith, there will still be the right of private action. You'll hear that from my colleagues on the other side of the aisle, that this somehow relieves the right of private action. It does not. It just ensures that there's a good faith exception. If somebody was just trying to do everything right but missed a comma or a period or accidentally did something trying to comply, then they will have that defense in court and be able to ask the case to be withdrawn. This hold harmless provision ensures that borrowers and lenders and realty agents and others won't be forced to delay closings as they figure out how to deal with almost a 1,900-page rule. I look forward to debating the bill on this bill with my colleagues on the other side, and I urge support of the rule and the underlying legislation. Mr. Speaker, I reserve the balance of my time.
The gentleman reserves. The gentleman from Massachusetts is recognized.
Thank you, Mr. Speaker. I thank the gentleman from Ohio, Mr. Stivers, for the customary 30 minutes. I ask unanimous consent to revise and extend my remarks, and I yield myself such time as I may consume.
Without objection, so ordered. You're recognized.
Mr. Speaker, I rise in very, very strong opposition to this closed rule, which provides for the consideration of H.R. 3192, the so-called Home Buyer Protection Act. Today's rule marks the 42nd closed rule we have considered during the 114th Congress, the 42nd. More than half of all the rules we have reported of the Rules Committee have been closed, completely closed, and a majority of the bills the Rules Committee has sent to the floor have drawn a veto thread, and this bill is no exception. I ask unanimous consent to insert into the record the Statement of Administration Policy saying that if the President were presented with H.R. 3192, his senior advisors would recommend that he veto this bill.
Without objection, so ordered.
You know, when the Republicans took the majority in 2011, Speaker Boehner and the entire Republican leadership promised the Democrats a right to, and I quote, a robust debate and an open process, end quote. He promised us the opportunity to make our case, to offer alternatives, and to be heard. Instead, the Speaker has presided over the most closed Congress in the history of the United States of America. And Democratic alternatives are often prevented from coming to the floor. By the way, not only are Democratic alternatives prevented from coming to the floor, Republicans can't even bring amendments to this bill because it is totally closed. Now, I know my friends on the other side of the aisle are meeting as a conference tomorrow to choose a nominee to become the next Speaker, and you have other leadership battles ahead. I hope that they are able to have an honest discussion about the ability to work through regular order and an open process that allows the House of Representatives to work its will and for both parties to be heard. Now, maybe my friend from Ohio can help me understand why an amendment offered by the ranking member of the Committee of Jurisdiction, Ms. Waters, an amendment that would protect consumers was not made in order. I mean, we would have preferred an open rule. We would have preferred that many amendments would be made in order. But the ranking member of the Committee of Jurisdiction had an amendment that is germane to this bill, and it wasn't made in order. I don't quite understand it. Well, one amendment, just one. Maybe it was an oversight. Mr. Speaker, I'm going to ask unanimous consent that we amend this rule and allow that the Waters Amendment be allowed so that we can debate it.
Does the gentleman from Ohio yield for the...
I do not.
The gentleman does not yield.
Just one amendment. That's it. It's one. We're not asking for two. We're just asking for one.
Yield me time to respond to his question?
I yield to the gentleman.
Thank you so much. So the ranking member, I happen to serve on the Financial Services Committee with the ranking member, and that idea was not offered in the committee, so it was a new idea. I will tell you that it sort of conflicts with the good faith exception, because what her amendment said was that nothing would get in the way of somebody's private right of action. The whole point of the good faith exception in the bill is to ensure that judicial proceedings happen the same way as administrative proceedings.
I reclaim my time. So the excuse is that this was not made in order because the ranking member did not offer this in committee. Who cares? We have a debate on the House floor. This is supposed to be a deliberative body. We're supposed to be able to debate these things. The gentleman didn't say it was not germane. The gentleman didn't say it needed special waivers to be made in order. He just...
So what Mr. McGovern has suggested here is that they're not going to handle court cases judicially. They're going to handle them administratively. And that is exactly what they're doing under legislative bills, and they're bringing in fake mortgages into the court cases.
Said, hey, she didn't bring it up in the full committee, so we decided in the Rules Committee to say, no, you don't have the right to be able to offer this and debate it. Please. I mean, come on. This place, is becoming a place where serious issues are not even allowed to have a debate. I'm not even asking you to vote for it. I'm just saying allow there to be some debate. When I travel through my district, Mr. Speaker, I hear from constituents who are fed up with this Congress. They're fed up with the process. They always want to know, why can't you at least debate important issues that are relevant to our lives? And, it's hard to explain that the Republicans just want to shut everything out. And in this bill, it's no exception. I talk to people who think this place is no longer a serious legislative body. And they have a point, because we don't really debate serious things anymore. I mean, we have things like this Benghazi commission that has cost the taxpayers millions of dollars, that the Republican majority leader admitted on a very conservative TV station that it was nothing but a political ploy to try to get Hillary Clinton's poll numbers down. I mean, I guess it didn't come as a surprise to me. It came as a surprise that he was so candid in his admission of what this was all about. There's time to debate a special select committee to yet do another investigation of Planned Parenthood, and we don't even know how much that's going to cost, because when it was brought before the Rules Committee last night, there was no amount of money that was provided or told that they would need. So that would be millions and millions of more dollars that the taxpayers will have to come up with in order to fund this another political witch hunt. But there's time for these political maneuvers, but there's no time for serious debate on serious issues. It's just wrong. We're not focusing on priorities that matter to people. My constituents want to know what we're doing to make college more affordable. Are we doing anything to help create jobs, to create economic opportunity? But we're not working on these priorities. We've become kind of an arm of the Republican Congressional Campaign Committee, where everything is politically charged. Everything has to be a wedge issue. So here we are today, bringing to the floor legislation that's going nowhere. bills that will likely not be taken up by the Senate, and as I mentioned, will be vetoed by the President of the United States. So this is the business as usual. You know, the Dodd-Frank financial reform law required the CFPB to combine the disclosure forms required under the Truth in Lending Act and the Real Estate Settlement Procedures Act into a single unified form. On October 3rd of this year, the final TILA-RESPA rule took effect, giving consumers a clearer understanding of the costs of buying and financing a home. The underlying bill establishes a hold harmless period through February 1st, 2016, where lenders would not be liable for violations of the rule requirements so long as they made a good faith effort to comply. But the Federal Financial Institution Examination Council, comprised of the prudential regulators, has already agreed to restrain supervisory authority during the initial implementation of the rule. And the Consumer Protection Bureau has implemented a restrained enforcement period. So what are we doing here, Mr. Speaker? Throughout this process, CFPB has demonstrated its desire to get this rule right. They've worked with us. They've responded to the letters that we have signed. They've listened. They're doing what we want them to do. The Bureau has engaged with industry to ensure smooth implementation of the rule and has been responsive to the concerns addressed by stakeholders and all of us. In fact, last May, as the gentleman pointed out, 250 members of Congress joined together on a bipartisan basis to urge the CFPB to announce and implement a grace period for those seeking to comply in good faith from August 1st to the end of 2015. If the regulators have promised to carefully consider an entity's good faith efforts to comply with the new rule while monitoring for compliance, why do we need a legislative fix? Why do we need to micromanage the CFPB? But this, to be honest with you, this bill, and this is where the problem is, it goes beyond more than redundancy. You know, if my colleagues have nothing better to do but pass things that are basically redundant, you know, I can go along with that. But this goes beyond redundancy. Unfortunately, this bill goes beyond simply providing good faith actors a grace period. This bill also strips borrowers of the opportunity to seek legal recourse under the Truth in Lending Act during this period. It would shift to the consumer the burden of proving a lender acted in bad faith and prevent consumers from even having the opportunity to have their day in court. So let me be clear, Mr. Speaker, we support a grace period for lenders acting in good faith. And if that's what this was all about, you could have brought this up under suspension and it would have just sailed through. Director Cordray of the CFPB also supports a grace period. And I'm finished. A grace period, and he's agreed to one. The regulators have responded to requests from industry and have outlined their policy for examination and supervision during this transition period. But I am very concerned with the road that we are traveling down. Home buyers should have access to the courts if a lender acts in bad faith. And I can't understand why my friends on the other side of the aisle are so intent on taking this critical consumer protection away. Now, as I mentioned earlier, my friend, the ranking member of the Committee of Jurisdiction, Maxine Waters, offered an amendment last night in the Rules Committee to improve this bill, to restore the private right of action under the Truth in Lending Act that is suspended by H.R. 3192. Now, if my colleagues on the other side of the aisle don't think that her amendment has merit, they could debate that and they could vote against it. Instead, what they have done is brought a rule to the floor that prohibits Ranking Member Waters from even offering that amendment. It is germane, it is relevant, it is a serious concern for those of us who care about consumers, but we don't have that opportunity. We don't have that opportunity. Totally closed rule, totally closed process. So the Republicans have prevented that important amendment from reaching the floor, and we're not going to have an opportunity to debate that today. So I would urge my colleagues to join me in voting no on this rule and no on the underlying legislation. And I would especially make an appeal to some of my Republican friends on the basis of process. I know a lot of my Republican friends are getting sick and tired of this kind of heavy-handed approach to important bills when the Rules Committee just shuts everybody out. If you want that to stop, then we need more votes with us opposing these closed rules. With that, I reserve my time.
The gentleman reserves. The gentleman from Ohio.
Thank you. To the gentleman from Massachusetts' remarks, Mr. Speaker, I agree with him that we should have more time to debate serious issues. And in fact, this bill should have been on the suspension calendar, but the ranking member of the Financial Services Committee refused to sign off on putting it on the suspension calendar. If it would have been on the suspension calendar, we would have had more time to discuss and debate other issues. I would like to read from the bill, since we deemed the bill read, and I'll start in the middle of line 9. Regulations issued under such sections may not be enforced against any person until February 1st, 2016, and no suit may be filed against any person for a violation of such requirements occurring before such a date, so long, this is the key part, so long as good faith effort to comply with the requirements. So the arguments that the gentleman from Massachusetts just made about somebody doing it in bad faith, they would not be covered by that part of the bill. It is black and white. It is really clear. And I am curious if the gentleman from Massachusetts would enter into a colloquy with me. Would the gentleman from Massachusetts enter into a colloquy with me?
Sure, happy.
Thank you. So
yeah.
I have a question. If the CFPB did indeed institute a grace period for individuals, yet those same individuals chose to file suit because without the language on a grace period for lawsuits with good faith compliance, would there indeed be a grace period at all?
Yes.
No, there would not. Because, reclaiming my time, if they can file lawsuits, the law, we haven't changed the law, and in fact, all we've added is a good faith exception that allows somebody to defend themselves and get a lawsuit dropped. So there's nothing in this bill that would protect anybody that acts in bad faith.
This bill shifts to the consumer the burden of proving a creditor acted in bad faith. And that puts more of the burden on the consumer. And if that's what the gentleman wants to do, fine. We have a disagreement.
Reclaiming my time.
We want Ms. Waters to be able to have her amendment so we can debate that issue.
Reclaiming my time, I would disagree with you. It does not shift the burden. It proves that the individual has to have the burden of proof that they acted in good faith. It does not say anything about the consumer showing somebody acted in bad faith. The individual defending themselves has to prove to the court that they acted in good faith. That is there's no shift of the burden here. The burden is on the individual. Here.
Let's have an amendment and let's have that debate and let's vote on it.
Well,
that's all I'm asking.
And
so we disagree.
Thank you. Reclaiming my time. The problem with the amendment, the problem with the amendment was it would have conflicted with that good faith language, and somebody could have pointed to that section and said, see, nothing can take away my right to sue. This good faith exception takes away my right to sue. Even though they acted in good faith, that denies me a right. And so it was conflicting language.
On the amendment, what is wrong with bringing this amendment up and debating it? That was the question.
I hear your point there, but I can tell you that if we would have debated the amendment, I believe that it would have been defeated. And frankly, the problem with it was if it would have been narrowly crafted to keep the good faith exception, I would have been okay with it. So, reclaiming my time, I do believe that we should be debating serious issues. I do believe that the private right of action is kept intact. There is only a good faith exception, and the burden is on the individual who acted, who the lawsuit will be brought against, to prove that they acted in good faith. That is how it works. Nobody's going to have to prove that they acted in bad faith. They're going to have to prove they acted in good faith. Nobody's going to give them a wink and a nod and the benefit of the doubt. The individuals who are being sued will have to prove that they acted in good faith. And if you made the regulatory accommodations for a grace period, but not the accommodations in the legal system, there's no grace period at all. It just takes away the entire grace period, because anybody that wants to sue just goes ahead and sues. That, it doesn't matter that there's a grace period administratively. There's no grace period in the law, and that's why that good faith exception is so important. So I reserve the balance of my time but I wanted to address those issues.
The gentleman reserves. The chair
And I am
reminds
prepared to close when the gentleman is finished.
the chair reminds the parties during debate to yield time to one another. The gentleman from Massachusetts is now recognized.
Again, I mean, we have some serious disagreements with the gentleman over how this bill adversely, in our opinion, adversely impacts consumers. This good faith exception is not in the current law as it stands. This is new ground that this bill is moving us toward, and there are some real serious concerns for consumers. And all we're saying is, again, our priority is the consumers. But if that's not the priority of my Republican friends, fine. You can defend you can defend what the language that you put into this bill, but this controversy over this, and we ought to be able to debate it. And to simply say, oh, if we made it in order, it would fail anyway. Is that going to be the new kind of standard for making amendments in order, that we're only going to allow amendments to come to the floor that we absolutely know will pass? Boy, that's a whole new standard that the Rules Committee and the Republican majority are now going to try to enforce. Again, one amendment, one by the ranking member of the Committee of Jurisdiction. One. That's it. One. Give her 10 minutes. I mean, I don't get why this had to be completely closed. But in any event, you're in charge. You can do whatever you want, and this place is being run under the strictest, most closed process, as I mentioned before, in the history of the United States of America. At this point, I'd like to yield 5 minutes to the gentleman from California, the distinguished ranking member of the Committee on Financial Services Committee, Ms. Waters, whose amendment was germane and was deliberately not made in order by the Republicans on the Rules Committee last night. I yield her 5 minutes.
The gentlewoman from California is recognized for 5 minutes.
Thank you very much. I'd like to thank Mr. McGovern, our ranking member of the Rules Committee, for the defense that he is putting up relative to my amendment. Yes, I went to the Rules Committee, and yes, I attempted to have an amendment that would protect our consumers. And so it is clear that the opposite side of the aisle did not want the public to know about this amendment. Why didn't they want this amendment debated? It is because they know that our consumers need to have the kind of protection that would allow them to go in court.
Minutes.
Thank you very much. I'd like to thank Mr. McGovern, our ranking member of the Rules Committee, for the defense that he is putting up relative to my amendment. Yes, I went to the Rules Committee, and yes, I attempted to have an amendment that would protect our consumers. And so it is clear that the opposite side of the aisle did not want the public to know about this amendment. Why didn't they want this amendment debated? It is because they know that our consumers need to have the kind of protection that would allow them to go in court and raise the question about whether or not, or questions about whether or not they're being defrauded, they're being misled, they're not being told the truth when they close on these mortgage deals. And so, because the Rules Committee decided that we could not have the debate on my amendment, we have to take every opportunity to try and unveil why they're keeping this amendment down, why they don't want to debate it. As a matter of fact, I am so surprised that my colleague on the opposite side of the aisle tried to make this sound as if the Democrats didn't want a grace period, that we didn't want a hold harmless period. That is absolutely not true. We agreed with Mr. Cordray, who heads the Consumer Financial Protection Bureau, that there should be a grace period. We understood when the industry talked about the fact that they had a lot of work to do to make sure that they got the right forms, that they trained their people, that they came in compliance with the new rules that were created under Dodd-Frank. So we agreed. Okay, Mr. Cordray said, I will not implement enforcement. I understand what you're saying, and Democrats agreed. We have said a grace period is okay. You keep trying to debate this bill about the grace period. That is not an issue. That is not an issue at all. We agree to the grace period. Go do your work, get your papers all worked out, get your staff all trained, but that's not what this issue is about. This issue is about where do you stand with consumers. Are you willing to say to consumers that if, in fact, you believe that you have been harmed in this closing, that all of a sudden the estimated costs are highly different or so different from what the final costs are? If you want to say to the consumer, you don't have a right to go into court and raise that question, then you're against the consumers. The consumers should have a right to have their day in court despite the grace period. The grace period should not be a period where you simply are getting your papers in order and you're training your staff. It should be a period where you still have a guarantee that you're not going to be tricked at closing time, that you're not going to be misled, that you're not going to be undermined in any way. If you want this to be a grace period where folks can say, I have an opportunity now, the lender can say, I have an opportunity to get a little more money out of this deal. And then you would say, if they misled the consumer, that the consumer does not have a right at all to raise a question about it. I don't think so. And so we on this side of the aisle, we stand with the consumers. When consumers decide to purchase a home, it is the biggest purchase of most people's lives, and they should be afforded the broadest recourse available under the law. Many errors can occur in this complicated process, some made in good faith, some that are not. For example, a lender might fail to properly disclose key loan terms such as annual interest rates, finance charges, and other critical information associated with purchasing a home. If a borrower feels that they have been harmed, they should have an opportunity to have their day in court without limitation. I fully support the Consumer Financial Protection Bureau's announcement that it would engage in restrained enforcement actions against lenders under their new mortgage disclosure rules. The Bureau made similar assurances in response to their mortgage underwriting and servicing rules that went into effect last year. And I fully expect the Bureau to do the same with these new disclosure rules that they've always done, to be responsive to Congress, industry, and other relevant stakeholders, and to make thoughtful decisions on the best way to proceed in protecting consumers. I have no reason to believe that they will not be as thoughtful in their approach to the new mortgage disclosures as they were with the mortgage underwriting. Thank you. And servicing rules. While I also support the provisions of H.R. 3192 that are consistent with the CFPB's action to date, my support ends when vital consumer protections like the private right of action afforded to consumers under the Truth in Lending Act are weakened or worse, completely eliminated. Under current law, consumers that feel that a lender provided an inaccurate or misleading mortgage disclosure can file suit under the Truth in Lending Act, and lenders are forced to prove that the disclosures they provided were consistent with the Act. The burden of proof is properly placed with the lenders as they have the resources to prove their good faith, intent, and consumers often have limited information at the time they file suit. H.R. 3192, however, would shield the lenders from liability if an error was committed in good faith, even if a consumer relied on this information to their detriment. The act or the effect of the good faith provision is that it requires that consumers prove from the onset of an action filed against a lender that an error was not made in good faith, a burden of proof that a borrower simply lacks the means to make. As a result, the good faith requirement in H.R. 3192 operates as yet another hurdle for consumers and is harmful departure from current law. And so I offered the amendment, and Mr. McGovern is correct. Why couldn't we have a debate on it? It's a very simple amendment. And this would help provide clarity to the marketplace while also protecting consumers. The amendment would simply restore a consumer's existing rights under TILA to bring an action during the temporary safe harbor period established by H.R. 3192, even if the action was filed in response to an error made by a lender in good faith. So let me just say, whose side are you on? Are you on the side of consumers who expect you to protect them? We have gone through a crisis in this country. We had a subprime meltdown. We discovered that consumers had been tricked. People buying homes had been misled. We discovered that they had loans that, well, they didn't even understand. And so we don't want to go back there. We want to protect consumers, and we have a right to do that. This amendment would have helped clarify that. You did not afford us that, and I yield back to the balance of my time.
Does the gentleman from Massachusetts, you reserve?
Yeah, I do.
The gentleman from Massachusetts reserves. The gentleman from Ohio.
Thank you, Mr. Speaker. A couple things I want to make clear. Earlier in my remarks, I acknowledged that the other side of the aisle agrees with us on an administrative grace period. The problem is if they don't agree to both an administrative grace period and a grace period with regard to lawsuits for people that acted in good faith, the key words here are good faith, then there is no grace period because people will just choose to go sue during the grace period and there will be no grace period. It was good to hear the gentlelady from California acknowledge that this is only a temporary good faith exception. It only lasts until February 1st of 2016. It is just like the administrative grace period, and it only protects people in good faith. And, Mr. Speaker, I would just ask the gentlelady from California whether she believes somebody can act in good faith and also deceive and mislead at the same time, because her remarks imply that you can act in good faith while misleading and deceiving people. I would argue, I'm not an attorney, but I would argue that good faith is really clear, and you're not acting in good faith when you deceive and mislead. Again, this bill should have been on the suspension calendar. We shouldn't even have to be wasting time, valuable time that we should be dealing with really important issues, as the gentleman from Massachusetts acknowledged earlier. But I did want to correct the record on a few of those things. And I think the key difference we have here is about whether good faith means anything. I would argue that the courts have found good faith means something. And every American knows what good faith is. This does not shift the burden. Those people being sued have to prove they acted in good faith. So I think this is a really clear bill that provides a grace period for a limited amount of time through February 1st, 2016. But you have to provide both an administrative grace period and a grace period in the courts, or there's no grace period at all. Mr. Speaker, I'd like to yield 3 minutes to the gentleman from Kentucky, a distinguished member of the Financial Services Committee, Mr. Barr.
The gentleman from Kentucky is recognized.
Mr. Speaker, I applaud and thank my colleague from Ohio and my colleague from Arkansas for their leadership on this issue. On May 22nd, I sent a bipartisan letter with my colleague, Congresswoman Maloney, to CFPB Director Richard Cordray requesting a grace period for compliance with the TILA-RESPA Integrated Disclosure Rule, or TRID. The letter was signed by 254 members of Congress. Of those, 92 were Democrats. TRID is a complex rule in compliance terms, requiring new, untested software to harmonize data from realtors, mortgage brokers, lenders, land title agents, and others involved in the closing process. All that our letter requested was a grace period for those making good faith efforts to comply with the rule. No delay in the rule, no reproposal, just a grace period. We have listened to our constituents, and what they tell us is that innocent mistakes are inevitable as the disclosure software is tested in the real world for the first time. In fact, CFPB cited a mistake as the reason to delay implementation of the rule from August 1st until this past Saturday, October 3rd. However, that delay and promises of sensitive enforcement do nothing to provide certainty that honest mistakes made during the early days of TRID, when these untested systems are used in real transactions, will not be punished with fines and lawsuits. If the Bureau is allowed to make mistakes, then our constituents should also be allowed to make innocent mistakes without penalty for a brief period of time to establish the systems necessary to reliably comply. The Bureau, however, has proven unwilling to act. So today we consider a bill that implements the grace period requested in that letter. The Home Buyers Assistance Act simply provides a grace period until February 1st, 2016 to ensure that home buyers and sellers can be assured their transaction will not be delayed and industry participants won't need to fear enforcement actions or frivolous lawsuits over data entry issues or typos. It's what 92 of our Democratic colleagues requested just 5 months ago. But today, faced with a legislative solution to the problem, our colleagues are balking. The President has issued a veto threat. Leader Pelosi is whipping her members against the bill. This is quite baffling. It seems to me that the interests of trial lawyers are trumping those of consumers trying to buy or sell their homes. Make no mistake, allowing immediate legal liability under TRID only benefits litigious attorneys and overzealous bureaucrats. So I rise in support. Absolutely correct. We should be on the side of consumers. What my constituents tell me back home is that this, unfortunately, this new regulation doesn't simpler. In fact, the number of pages are the same. And look at the regulation. Is this pro-consumer? This is the regulation from Washington. This is complex. This is not simplification for consumers. This makes the home buying process more difficult.
Gentlemen, another 2 minutes.
Thank you. This makes the home buying process more difficult for consumers. But at the end of the day, even if we're going to go forward with this new complicated regulation, 1,800 pages or so, at least give the participants, the closing attorneys, the title insurance agents, the realtors, the advocates for the home buyers, the advocates for the consumers, let them have a brief period of time where they can get up to speed with the complexity of this rule so that innocent mistakes are not punished and that home buyers are not punished. Let's set the politics aside on this. This is not about Democrat or Republican here. We've got a big bipartisan letter. This is something that protects our constituents. This is what our constituents are telling us they need to come into compliance with this new complex law. Isn't buying and selling a home, isn't moving from home to home complex enough? Let's not let the bureaucrats make it even more difficult. And with that, Mr. Speaker, I yield back to my friend from Ohio.
I continue to reserve, Mr. Speaker.
The gentleman from Ohio reserves. The gentleman from Massachusetts.
Well, thank you, Mr. Speaker. Let me just say to my friend, the gentleman from Kentucky, I signed his letter. I agree with him. Should be a grace period. And if that's what we were talking about right now, I don't think there'd be much of a debate. But and we got what we wanted. But yes is not a good enough answer from some of my friends on the other side of the aisle. So you bring something that, you know, might be a redundant bill. But I'd be less exercised over voting for a redundant bill if that's all it was. But you expanded it. You added. Basically, you added something that we strongly believe jeopardizes consumers. Now, what makes us even more exercised over here is that the Rules Committee reported out a rule that denied the right of the ranking member of the Financial Services Committee, Ms. Waters, to bring an amendment to remedy that to the floor. Totally closed rule. You know, I mean, the one controversial part, real controversy about what we're doing here today is this provision that we think hurts consumers, and we can't have a vote on it. The amendment was germane. She's a ranking member. We're only asking for 1 minute. We're not doing anything else here of any consequence. We're not trying to figure out our long-term budget problems. You know, so you could give us another 10 minutes to debate an amendment. And you've chosen to not do that. And I just say one other thing. Everybody holds up that prop, the 1,800 pages of regulations. But let's just help break it down, because we're into a lot of props in this place. We ought to also understand what the facts are. First, the 1,800 pages are contained in a double-spaced document. The text in the Federal Register is actually not 1,800 pages, but 634 pages, roughly a third of that. The rule itself, the regulatory text, is only 26 pages. Only 26 pages. 171 pages are sample and model forms, which, you know, my friends on the other side of the aisle say, you know, we want the agency to help, you know, provide industry with concrete guidance. So there's 171 pages of sample and model forms in there. And we have further breakdown here if my friends are interested. But let's be clear. None of us here object. In fact, we all support the grace period. That is not what is contentious about this debate. It is this anti-consumer provision that has been inserted in this bill by my Republican friends that have us concerned. At a minimum, the Rules Committee ought to have allowed for there to be a debate where that could be voted up or down. If my friends don't like it, they could vote no. But instead we hear excuses. Oh no, it wasn't offered in the full committee, as if that somehow is a reason to deny a member the right to offer an amendment to the floor. Oh, we can't make it an order because it won't pass anyway. A new standard now by the Rules Committee in terms of what will be made in order. Just give us the amendment. Let's have a real debate. Let's actually be deliberative for a change here. And with that, I reserve my time. I reserve my time. Yeah.
The gentleman reserves. The gentleman from Ohio is recognized.
Would the gentleman from Massachusetts enter to a quick colloquy with me? I am curious if you are arguing, because it sounds to me, Mr. Speaker, like the gentleman from Massachusetts is arguing that we only want to give people protections from administrative actions. We don't want to give them equal protection in the courts that they're getting from administrative regulations when they're acting in good faith. Is that what you're arguing?
What I'm arguing,
if they're acting in good faith, they should still be allowed to be sued, and they should still have all the penalties for a wrong comma, even if they were acting in good faith. I'll yield you some time in a second. But is that what you're arguing? If there's a comma misplaced or they accidentally tried to comply but in good faith made an accident, you think they should suffer all the slings and arrows in court, even though they wouldn't suffer any slings and arrows from regulators? I yield the gentleman from Massachusetts time to answer that question.
What I'm arguing is that the burden should be on the consumer, and your legislation adds a whole new dimension to this debate that, quite frankly, has us concerned. And at a minimum, it deserves a debate on this floor. This is the rule. We are debating how we're going to debate the underlying legislation, and I have not yet heard one reason why we can't have an amendment to try to correct what we think is an injustice and a potential harmful impact on our consumers.
Reclaiming my time, I didn't hear an answer there, but the point is people deserve equal protection during a grace period in the courts if they acted in good faith. The key here is good faith. It's written right into the bill. They deserve the same protections in court if they act in good faith that they deserve from administrative action from the regulators. They deserve the same help and remediation to get their attention correct, or their deficits corrected, as opposed to punitive action. The problem is without that provision, and let me add, this is a temporary provision until February 1st, 2016. The good faith protections don't even last past February 1st. It's the same protection for the same time period in the courts as from administrative action. I also yield a minute to the gentleman from Kentucky.
The gentleman from Kentucky is recognized for 1 minute.
Well, I thank the gentleman, and just briefly in response to my colleague from Massachusetts and the analysis that this is a prop. This 1,800-page regulation is just a prop, and he blames about 171 pages on explanations and guidance and suggests that, well, that's a good thing. We want explanations and guidance from the bureaucrats to explain how this works. Let me tell you what my constituents back in Kentucky are telling me what happens in the real world. In the real world, how closing attorneys, this is a closing attorney in Kentucky who says this, interprets this stack of paper, and he says, I'm going to have to do 2 closings. A TRID-compliant closing, and then another closing that actually informs my client what's going on in the transaction. Now, is that simplifying things for consumers? Does that make things easier for a home buyer and a home seller to have 2 closings? One that's TRID-compliant, compliant with the bureaucracy, and one that actually helps the home buyer with a HUD settlement statement? I don't think so. And so I would yield back.
Gentleman, an additional minute.
And so the point here is, and I thank the gentleman, the point here is that we should be making things easier. And if it's so daggone complicated that you have to have 2 closings, at least give us 6 months to figure this thing out. 6 months of a grace period for good faith efforts to come into compliance where innocent mistakes happen. Yield back.
Mr. Speaker, I would request how much time each side has.
The gentleman from Ohio has 6 minutes. The gentleman from Massachusetts has 6.5 minutes.
I continue to reserve my time, and I would inform my colleague I am prepared to close.
The gentleman reserves. The gentleman from Massachusetts.
Mr. Speaker, let me again say we have no objection to a grace period. In fact, we support it. We signed the gentleman from Kentucky's letter. That's not the controversy here. It is what we think a language that could do potential harm to consumers. And let me just say to the gentleman, in the real world, we have seen consumers get a raw deal time and time again. And in large part because of the lack of oversight and the lack of defense that they get in this chamber. So, yeah, we are standing up for consumers because we don't want to see them continue to get a raw deal. And that's what we're concerned about. And if you want to disagree with me on that, fine. But that is no reason to not allow there to be a debate on an amendment that is germane to this bill that would correct what we think is a flaw in this legislation. And with that, Mr. Speaker, I'd like to yield to the gentleman from California, Ms. Waters, 2 minutes.
The gentlelady from California is recognized for 2 minutes.
Thank you very much, Mr. Speaker and members. We have to keep saying over and over again, this is not about the grace period. They keep arguing that somehow they favor a grace period and we do not. We have made it clear that's not what this debate is about. We support a grace period. Not only that, Mr. Cordray at the Consumer Financial Protection Bureau supports a grace period. That's not the argument here. The argument is what you don't want to talk about. My amendment that I attempted, and you came to this floor with a closed rule to keep us from talking about an amendment that would protect the consumers. My amendment would allow that the consumers have a right to have their day in court. And when you talk about good faith and the way that this bill is written, of course, when a consumer, in my opinion, when a consumer in this grace period takes a look at the documents, and if it is simply a comma, as one has indicated, well, that could be a mistake in good faith, and the lender will be okay. But when the interest rates change, when there are more fees than were anticipated, when the cost of that mortgage goes up and the consumer says, hey, this is not what I really intended, this is not what I agreed to, and the lender is saying, sorry, you know, that's it, that's what you signed up for, then the consumer has a right to go to court. And even though you would place the responsibility on the consumer to have to prove that the lender did not act in good faith, different from what the law is now, that consumer should have the right to go to court and make his or her case. And that's what this amendment is all about, and you know it. It's not about bringing your props in, trying to say this is the bill. That's not the bill. You have all of the comments and everything else that's associated with the bill. So let's get some truth out here and have people understand what the amendment is and not just props showing that you have thousands of pages of a bill. I yield back the balance of my time.
Gentlelady's time has expired. Does a gentleman from Massachusetts reserve?
Does the gentleman all?
I'll reserve. I'm prepared to close.
Okay, then I will yield myself the remaining time. How much time do I have left, Mr. Speaker?
The gentleman has 3.5 minutes.
Mr. Speaker, first I want to ask unanimous consent to insert into the record a letter signed by a number of consumer rights organizations, civil rights organizations, all opposed to this bill because of the provision that Ms. Waters and I have been talking about now for
without objection,
close to an
the
hour.
gentleman's letter is entered in the record.
And look, it's clear we have a disagreement here, and it ought to be resolved in an open and fair fashion with a debate and a vote on an amendment. We're not going to have that. So I'm just going to close by saying to my colleagues on both sides of the aisle, I've got a radical idea for what I think is the greatest democratic institution in the world, the United States Congress, and that radical idea is that we ought to allow a little democracy to happen here. We ought to not be afraid of debate. We ought to not be afraid of allowing at least one amendment, that's all, one amendment to come to the floor so that the concerns that we have voiced on our side of the aisle worry that consumers will once again become victims and get a raw deal could be avoided. We ought to have that debate, and we ought to vote up or down on it. This grace period is not, as I said, is supported by everybody. It's supported by, by the CFPB. I mean, we're all on board on that. That's not the controversy. Controversy is this added stuff, and the way the majority has decided to handle this, to shut the whole process down, that's, I think, beneath what this institution should be about. So I would urge my colleagues in the strongest possible terms, please vote against this rule. Send a message to the leadership here that we need to do this better. We need a better process. This process is lousy, and we all should be fed up with it. With that, I yield back my time.
Gentleman from Massachusetts yields back the balance of his time. The gentleman from Ohio is recognized to close. Gentleman has 6 minutes remaining.
Thank you, Mr. Speaker. I want to address the thing that the gentleman has continued to talk about, good faith. Good faith is known in all 50 states. It's been enacted in the Uniform Commercial Code. It is kind of interpreted two ways. There's two ways, and by the way, they hold defendants are the ones who have to prove they acted in good faith, not the litigants, not the people who bring the lawsuit, but the defendants have to meet one of two standards to prove they acted in good faith. Number one is a reasonableness standard. In general, they relied on something, they were reasonable in their dealings. The plaintiff does not have to prove anything, just the defendant. The second also uses reasonableness, but it's also makes sure it's about intent, and if they intended to comply with the standard, that's the other thing that the defendant brings forward. I want to be clear here. Nothing changes the standard for a plaintiff in this. So this whole argument about whether good faith, somebody can act in good faith and yet deceive people, any court in the land would say that can't happen. You can't deceive somebody and say you acted in good faith. That's not good faith. So we stand with consumers who want to close on their homes for the American dream in a timely way. We also stand by those who are trying in good faith to comply with 1,886 pages of regulation. It's important to note that this is a temporary standard through February 1st of 2016 to give people a grace period from both administrative actions and legal actions. You have to give them a grace period in both categories. If you only give an administrative grace period, as the other side of the aisle has argued, everyone will simply run to the courts, and there's no grace period there for good faith efforts. Good faith is important. It means something. We stand with consumers. We do not stand with trial lawyers. This bill allows a transition period to occur and ensure that buyers and sellers can have closings during that period, and those that are acting in good faith will be protected from both regulation and litigation. Mr. Speaker, I urge my colleagues to support the rule and the underlying bill. I yield back the balance of my time and move the previous question on the resolution.
Gentleman yields back the balance of his time. Without objection, the previous question is ordered. The question is on adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes have it. The resolution is agreed to, and without objection,
Mr. Speaker,
gentleman from Massachusetts.
I got to ask for the yeas and nays.
The yeas and nays are requested. Those favoring a vote by the yeas and nays will rise and be counted. A sufficient number having risen, the yeas and nays are ordered. Pursuant to Clause 8 of Rule 20, further proceedings on this question are postponed. For purposes generally from New York, seek recognition.
Mr. Speaker, I rise on the question of the privileges of the House and offer a resolution previously noticed.
Clerk will report the resolution.
Whereas the attacks in Benghazi, Libya on September 11, 2012 took the lives of U.S. Ambassador Christopher Stevens, Foreign Service Officer Sean Smith, and former Navy SEALs Tyrone Woods and Glenn Doherty. Whereas the events leading up to and in the immediate aftermath of the attacks on the U.S. consulate in Benghazi were rightfully and thoroughly examined to honor the memory of the victims and to improve the safety of the men and women serving our country overseas. Whereas the Independent Accountability Review Board, convened by the U.S. State Department, investigated the events in Benghazi and found no evidence of deliberate wrongdoing. Whereas 5 committees in the U.S. House of Representatives investigated the events in Benghazi and found no evidence of deliberate wrongdoing. Whereas 4 committees in the U.S. Senate investigated the events in Benghazi and found no evidence of deliberate wrongdoing. Whereas in each fiscal year, more than $4 billion is appropriated to run the Congress, with untold amounts of this taxpayer money expended by 9 congressional committees to investigate the events in Benghazi, none of which produced any evidence of deliberate wrongdoing. Whereas after the exhaustive, thorough, and costly investigations by 9 congressional committees, and the Independent Accountability Review Board found no evidence of deliberate wrongdoing, Republican leaders in the House insisted on using taxpayer dollars to fund a new, duplicative Select Committee on the events surrounding the 2012 terrorist attack in Benghazi, hereafter the Select Committee, to re-examine the matter. Whereas this taxpayer-funded committee was given broad powers to pursue its investigations, including an unlimited taxpayer-funded budget and granting the chairman the legal authority to subpoena documents and compel testimony without any debate or a vote. Whereas the ongoing Republican-led investigation into the events in Benghazi is now one of the longest-running and least productive investigations in congressional history. Whereas a widely quoted statement made on September 29, 2015, by Representative Kevin McCarthy, the Republican leader of the House of Representatives, has called into question the integrity of the proceedings of the Select Committee and the House of Representatives as a whole. Whereas this statement by Representative McCarthy demonstrates that the Select Committee, established by Republican leaders in the House of Representatives, was created to influence public opinion of a presidential candidate, whereas the Select Committee has been in existence for 17 months but has held only 3 hearings. Whereas the Select Committee abandoned its plans to obtain public testimony from Defense Department and intelligence community leaders. Whereas the Select Committee excluded Democratic members from interviews of witnesses who provided exculpatory information related to its investigation. Whereas information obtained by the Select Committee has been selectively and inaccurately leaked to influence the electoral standing of a candidate for public office. Whereas such actions represent an abuse of power that demonstrates the partisan nature of the Select Committee. Whereas the Select Committee has spent more than $4.5 million in taxpayer funds to date to advance its partisan efforts. Whereas this amount does not include the costs of the Independent Accountability Review Board, the hearings and reports by 9 congressional committees, the time, money, and resources consumed by federal agencies to comply with Select Committee requests, or the opportunity cost of not spending this money elsewhere, such as improving security for our diplomatic officers abroad, where it is an outrage that more than $4.5 million in taxpayer funds have been used by Republicans in the House of Representatives, not to run the government, but to interfere inappropriately with an election for President of the United States. Whereas the use of taxpayer dollars by the House of Representatives for campaign purposes is a violation of the rules of the House and federal law, resolved that 1, this misuse of the official resources of the House of Representatives for political purposes undermines the integrity of the proceedings of the House and brings discredit to the House. 2, the integrity of the proceedings of the House can be fully restored only by the dissolution of the Select Committee. And 3, the Select Committee shall be dismantled and is hereby directed to make public within 30 days transcripts of all unclassified interviews and depositions it has conducted.